Here are some guidelines for customers bringing onto or removing alcoholic beverages from a premises. A person may not bring onto the licensed premises of a retail licensee an alcoholic product for on-premise consumption, although, if the licensee allows it and the establishment is licensed for it, a patron may bring onto the premises a bottle of wine as long as it is corked, no larger than a 750 milliliter for tables of less than 4 guests or 1.5 milliliter for guests of 4 or more. If the patron carries the bottled wine onto the licensed premise, the patron shall deliver the bottled wine to a server or other representative of the retail licensee upon entering the licensed premises. The wine service can then be provided to the guests. The establishment has to be the one who opens the bottle and pours the first glass. The customers then may pour for themselves. Please note this: the bottle brought in has to be with either a cork or a screw top. Boxed wine cannot be brought in. If the guest does not finish the bottle of wine, either by purchasing it from the establishment or bringing it in themselves, and they don't finish it, they can take it home with them as long as it was consumed with a meal and is recorked or recapped. Now, because of this, we suggest this. You don't have to do this, just our suggestion. Draw a line on the bottle where the wine level is, initial and date it. Once the wine bottle is bagged, staple it closed with the receipt attached and ask the guest to please put it in the trunk of their car. Otherwise, they could be charged with an open container violation. Consuming or having an open container of alcohol in the passenger compartment of a motor vehicle is prohibited. In fact, a retail licensee may not permit a patron to carry from the premises an open container that contains an alcoholic product. When private events, as defined in 32B-1-102-77, are held on the premises of a licensed restaurant, the proprietor may, in his or her discretion, allow members of the private group to bring onto the restaurant premises their own alcoholic beverages under the following circumstances. Number 1, when the entire restaurant is closed to the general public for the private event, or Number 2, when an entire room or area within the restaurant, such as a private banquet room, is closed to the general public for the private event, and members of the private group are restricted to that area and are not allowed to commingle with public patrons of the restaurant. All advertising must be done in a responsible manner. It can never promote overconsumption or drunk driving, depict minors consuming or possessing alcoholic beverages, and it can never be directed or appeal primarily to minors. Utah Administrative Code R81-1-17 covers all rules concerning advertising. Liquor and wine must be locked up during the prohibited hours of sale, but wine or liquor for cooking purposes can be used at any time. Any bottles used in this manner must be labeled cooking flavoring. The administrative rules of the DABC Commission for full and limited restaurants, resort spas, and clubs state alcoholic product flavorings may be utilized in beverages only during the authorized selling hours. Alcoholic product flavorings may be used in the preparation of food items and desserts at any time, if plainly and conspicuously labeled cooking flavoring. Required signs. The health DUI warning sign consists of 2 messages, each of which has to be in a different font. The color of the print does not have to be red, and the sign does not have to be white, but it has to be easily readable and posted in a prominent place in the licensed premises. The signs, "This premise is licensed as a restaurant or bar," must be 8.5 by 11 inches and displayed in a conspicuous location near the front entrance. They must designate whether, in fact, you are entering a bar or a restaurant. Liquor laws affecting enforcement. The Department of Alcoholic Beverage Control is primarily a retailing and licensing agency, not a law enforcement bureau. Enforcement of Utah's alcohol laws is the primary responsibility of local police and sheriff's offices and the Utah Department of Public Safety Alcohol Enforcement Section. These agencies conduct open premise inspections and undercover investigations to determine violations of the liquor laws. If they find violations, they may refer the matter to a local prosecutor for the possible filing of criminal charges, and/or they may refer the case to the DABC, Department, and local licensing bureaus for possible action on a license. Once the DABC receives a referral from a law enforcement agency, they are required to determine whether action on a license is warranted. The Alcoholic Beverage Control Commission has given the Department of Alcoholic Beverage Control guidelines for processing violations to ensure that each violation is handled fairly and consistently. The Commission has grouped violations into 4 categories ranging from minor, moderate, serious, and grave based on the relative degree of severity. Obviously, violations that pose a risk to public safety, health, and welfare, or that include minors or acts of fraud, are considered the most serious and carry the greater penalties. The DABC screens the police report, determines the severity of the alleged violation, and then commences an administrative proceeding to determine whether a violation in fact occurred. Most cases are settled under guidelines set by the Commission. Those cases that go to a hearing are heard by an independent, outside hearing officer who issues findings and makes recommendations to the Commission for final action. The Commission may find the license, or suspend or revoke the license, and order the forfeiture of the license and compliance bond. The Commission may also order that the offending employee be suspended from employment with the department licensee for a period of time.